in what month of 2012?
July.
July. Okay. This matter comes before the court on the defendant's motion to suppress evidence that the defendant referred to Michele MacNeill as a bitch when speaking to inmates 3 and 4 and to Jason Poirier, a state inmate. Inmate 3 was interviewed by police investigators on January 8, 2013. His anticipated testimony will be that defendant told him authorities do not have evidence and cannot prove that he killed Michele MacNeill and that he referred to his wife as a bitch. This conversation occurred sometime after August 2009 when the defendant was incarcerated at Texarkana Federal Facility. And after the publication of the People magazine article in April of 2011. Inmate 4 was interviewed by authorities on January 8, 2013. His testimony will be that the defendant explained how to introduce controlled substances rectally. The defendant said he was being investigated for murder, but that no one can prove that he had done anything. When asked if he killed his wife, the defendant responded, "They think I killed 2 or 3 bitches." Again, the date of the conversation is sometime during the defendant's incarceration at Texarkana Federal Facility and after the airing of the Nancy Grace show related to this case on December 7th, 2010. Finally, Jason Poirier was interviewed by authorities early in 2013. His testimony would include the defendant's statement, quote, "I am glad the bitch is dead," in reference to Michele MacNeill, and his statement, "Well, for instance, I killed my wife, that should say a lot." The date of this conversation is sometime after December 10th, 2010 at the Utah County Jail. That's 2012, isn't it? Right. 2012. Yeah. Referring to Michele MacNeill as a bitch constitutes an other crime, wrong, or act. To be admissible, the evidence must be offered for a proper non-character purpose. It must be relevant, and the probative value of the evidence must not be substantially outweighed by the danger of unfair prejudice. The problem with Rule 404B evidence is that it carries with it dual inferences, both proper non-character inferences and improper character inferences. The state may not offer 404B evidence as a ruse for placing before the jury improper character evidence. Where a legitimate non-character purpose exists, the question under Rule 403 is which inference predominates, the proper non-character inference or the improper character inference. In weighing the probative value against prejudicial effect of Rule 404B evidence, the court considers the predominant purpose for which the evidence is offered, the strength of the evidence that the defendant committed the bad act, the similarities between the charged crime and the bad act, the interval of time that has elapsed between the charged offense and the bad act, the need for the evidence, the efficacy of alternative proof, the degree to which the bad act will arouse the jury to overmastering hostility, and the effectiveness of any limiting instruction. Here the defendant referred to Michele MacNeill as a bitch. That reference does give rise to an improper character-based inference. The defendant's derogatory reference to Michele MacNeill after her death is an expression of the defendant's contempt for her. The state cannot offer this evidence to show that the defendant acted in conformity with that feeling on April 11, 2007. murder being an act manifesting the ultimate degree of contempt for another person. Here, the state offers the evidence to show that the defendant's true state of mind toward Michele MacNeill, that he was not a caring, albeit unfaithful, spouse. Referring to Michele MacNeill in this derogatory way also corroborates the state's theory of the motivation behind the alleged killing of Michele MacNeill, namely that the defendant had commenced an affair with Gypsy Willis, Michele MacNeill was no longer valued by him, and Michele MacNeill stood in the way of the new relationship. These are proper non-character purposes for which the statements may be offered. Evidence that the defendant referred to Michele MacNeill in such a contemptuous way is relevant. A person who holds a woman in derision or contempt is more likely to kill her than a person who has kind feelings towards her. Turning to Rule 403, the court is persuaded that the non-character purpose for which the evidence is offered predominates. On the contempt continuum, there is a significant distance between calling Michele MacNeill a bitch and murdering her. The jury is not likely to draw the improper character inference, convicting the defendant of murder because he referred to Michele MacNeill in derogatory terms. Finally, the Shickles factors generally weigh in favor of admissibility. The strength of the evidence is not overwhelming. Jailhouse informant testimony is inherently suspect. However, the fact that 3 inmates in separate interviews report the same derogatory term used by defendant in reference to Michele MacNeill does lend some increased strength to the evidence. As stated, calling a person a derogatory name and murder are both acts manifesting contempt toward another, but these acts differ dramatically in degree. Similarity is not high. Michele MacNeill died on April 11, 2007. In each instance, the defendant's derogatory reference to Michele MacNeill occurred many years later, and in the instance of Poirier, some 5 years later. This lapse in time cuts against admission. The state does need the evidence, and alternative proof is not effective. This is a circumstantial evidence case. The state's evidence of motive consists of the affair with Gypsy Willis. However, not every man who has an affair devalues his spouse to the degree that he is driven to murder her. Evidence that the defendant viewed his wife and her death with contempt is strong evidence corroborating the state's theory of motive. The derogatory reference toward Michele MacNeill is not likely to lead the jury to overmastering hostility toward the defendant. The context in which each statement was made can be explored on cross-examination, and alternative reasons for the making of each statement argued. For example, the defendant, upon finding himself incarcerated, desired for his own protection to present himself as a person not to be trifled with. A limiting instruction would be generally ineffective, calling attention to the remote character inference that the jury is unlikely to draw anyway. For these reasons, the court finds that the probative value of defendant calling Michele MacNeill this derogatory name is not substantially outweighed by the danger of unfair prejudice. The defendant's motion to exclude evidence that he referred to Michele MacNeill as a bitch in conversations with inmates 3, 4, and Jason Poirier is denied. The motion to exclude defendant's statement to inmate 4 that, quote, they think I killed 2 or 3 bitches, however, is granted. The inference is that the defendant killed, or at least is suspected of killing, 1 or 2 other women in addition to Michele MacNeill. This statement is not offered for a proper non-character purpose. It does not reference the defendant's own state of mind or motivations, but rather the state of mind of police investigators. The only inference that can be drawn from this statement is the one expressly forbidden under Rule 404A. Because defendant has done violence to or is suspected of doing violence to one or two other women, he is more likely to have acted in conformity with this violent propensity or character on April 11, 2007. Even if this statement could give rise to a proper non-character inference, which it does not, the statement would be inadmissible under Rule 403. The only evidence presented that the defendant engaged in the killing of one or two other women is inmate 3's own statement. Jailhouse informant testimony such as this is inherently suspect and in this instance is not corroborated. The similarity between the other act evidence and the charged offense is high. This similarity creates significant risk that the jury would use the statement as character evidence and engage in what Justice Souter called preventative conviction. That practice is what Rule 404A is intended to thwart. There is no indication about the interval of time between the other act evidence and April 11, 2007. In a circumstantial evidence case, the state's need for evidence is high. The state must establish guilt link by link in an inferential chain. However, links which create a substantial danger of unfair prejudice are not permitted. The suggestion that the defendant has killed or is suspected of killing one or two other women will rouse the jury to overmastering hostility against him, and no instruction could cure this unfair prejudice. For these reasons, the court grants the defendant's motion to exclude defendant's statement to inmate 3 that, quote, "they think I killed 2 or 3 bitches." Inmate 3 will only be permitted to testify that the defendant referred to Michele MacNeill using this derogatory epithet. Is there any question regarding the court's ruling? Will you, thank you, will you have
maybe a moment to make sure that each witness is notified about the ruling, although I will say the court's exclusion of inmate 3's statement, I don't think the state was preparing to offer that anyway, but I'll make sure that that's clarified to them.
My concern is the context is such that he may say it when it needs to be limited solely as a reference to Michele MacNeill, if you'll have that conversation with him. Thank you. Since we last were together, the state has filed a written motion to reconsider the court's ruling regarding the defendant opening the door to certain 404B evidence. Did you receive that?
Yes, I filed a response.
I have not seen the response yet. Was that filed Friday? Electronically. I'll need to read that, and perhaps we can address that after trial today. Anything else this morning?
I have 2 matters, Your Honor.
Go ahead.
The first one is regarding the joint stipulation about suicide not being a manner of death. In this case, I prepared a brief stipulation both parties have signed.
Is that correct?
That is correct, Your Honor.
The court will approve the joint stipulation, order that it be made a part of the record, and direct the state to prepare an instruction to that effect.
And Your Honor, I have one other matter regarding cross-examination on Mr. Poirier today. The state moves to exclude certain extrinsic evidence in his cross-examination as not being probative of his truthfulness, and I can go through specifics in a minute. This motion is based on predominantly on Rule 404A, which applies the prohibition of using character propensity evidence against any person, not just a defendant, not just a defendant. It creates exceptions under Rules 607, 608, and 609 for the impeachment of witnesses. However, the applicable rule here, I believe, is 608, specifically subsection B. 608A allows other witnesses to testify about a person's reputation for truthfulness or untruthfulness. 608B specifically excludes specific instances of conduct that would be used to attack a witness's credibility. It does provide the court with discretion to allow cross-examination on specific instances of conduct if those instances are probative of a character for truthfulness or untruthfulness. A couple of cases that the state believes are instructive on this. State versus Gomez, it's a 2002 Utah Supreme Court case. In this case, the defendant Gomez sought to introduce evidence that his rape victim used a fake identification to get into bars and to drink while underage. In its analysis, the court recognized that the general rule is that this type of evidence is disallowed, but it recognized the court's discretion. The trial court in that case used its discretion and applied a 403 balancing test to that impeachment evidence. In Gomez, the Supreme Court recognized the 608 plus 403 factors in that analysis being whether the specific instance of conduct is probative, or what the probative value is of the proffered testimony regarding truthfulness or untruthfulness, the degree to which that proffered testimony inflames or will prejudice the jury, either against the witness unfairly or by confusing the issues, creating a mini trial within a trial about whether the prior instance happened or not. And then it requires the balancing of that probative value against the prejudicial effect. In that case, the Supreme Court held that the victim's use of a fake ID had a very low probative value for truthfulness, and that it did not outweigh the potential to inflame the jury and distract them from the real issue of the case, that is the rape charge against Gomez. Obviously, the state's concerned here that Mr. Poirier has a criminal history that involves several misdemeanors that do not involve outright dishonesty.
That's a 609 issue, isn't it?
Some of it is, and if the court will allow, there are some things that he's not been convicted of, I think, that would fall under 608.
Okay.
Bullock versus Ungricht, it's a 1975 Utah Supreme Court case, stands for the principle that evidence of mere misdoings or misconduct may not ordinarily be used to impeach the credibility of a witness. This is particularly true if the primary purpose is to cast aspersions or besmirch the character, Rule 404A evidence.
The general character as opposed to character for truthfulness.
That's correct. Yes,
yeah.
that's correct. In that case was a dispute over whether it was proper to admit the plaintiff's prior bankruptcy and default judgment or judgments of default in her financial past. The court ultimately allowed it because she had put her credibility on those issues at stake through her damages claim. I think that's distinguished in this case because some of Mr. Poirier's prior conduct does not really speak to his credibility. Finally, State versus Valdez is a 2006 Utah appeals case that says that the court's discretion in restricting inquiry into a witness's prior bad acts is especially broad when inquiring about prior bad acts that did not result in the conviction of a crime. Based on prior motion from defense counsel about Mr. Poirier and other inmates, as well as the evidence that both parties have been able to gather about him, there are certain acts or alleged acts that the state believes are not probative of his truthfulness. The fact that he had guns and knives in violation of probation, the fact that it's alleged on jail phone calls he can be heard using or admitting to use of steroids and directing his wife to sell steroids to others. The fact that he allegedly...
I'm just making notes, I'm sorry.
No, if I need to go slower, that's fine. The fact that they were acquiring prescription drugs from a Dr. Moore and then selling them to...
By false pretenses?
I don't know. And that's one of the unknowns, is that I believe the jail phone call talks about him, or he talks to his wife about acquiring their prescriptions. I don't know whether they're false pretense prescriptions or not, but they are acquiring drugs and allegedly selling them. That his toddler daughter was involved in this, in the sense that she can, there's a statement on the phone call about her carrying the drugs around.
The daughter?
Yeah, the little girl has drugs that she's carrying around as they're talking on the phone. That, I think, is highly inflammatory and doesn't speak anything about his truthfulness. There are conversations that they discuss not paying the landlord because they're short of cash and they're not sure what to do next, so they think the eviction process will take longer. We'll at least give them a window of time in which to kind of get their affairs together. They talk about getting financial help from the LDS bishop, discomfort in doing that, and why Mr. Poirier thinks, Mr. Poirier, who is in custody at the time, thinks his wife should pursue that.
Again, is there any evidence of false pretenses in that regard?
I can't, I think defense counsel would be better to speak to that, Your Honor. I don't know exactly. I think there may be, there are several of these conversations, and I'm having trouble piecing them out. But I think he may be encouraging his wife to make some misrepresentations to the bishop about, in order to secure some financial aid.
So if that were true, that would be probative of truthfulness, wouldn't it? You may have this 403 issue, but I'm just focusing on 608. That
may be, yes.
Okay.
But as the court pointed out, under 403, I think when people are in...
Its probative value may not be great.
That's correct. And
Right.
when people are in dire straits, they may do things in order to secure aid that are substandard when it comes to social norms, but I don't know that necessarily means that, well, its probative value is low, and the fact that they're trying to swindle the bishop, I think, is inflammatory.
Okay.
There's a phone call where Mr. Poirier is alleged to encourage his wife to move a car to avoid its being repossessed, move it to his mother's house. And on that point, Your Honor, I think I compare that to the case State versus Bruce. It's a 1989 Utah Supreme Court case that says that the admission of a prior retail theft and attempted burglary convictions were improper because they were not accomplished by fraudulent or deceitful means. I think moving a car so that it's not repossessed is analogous to that. He allegedly made threats against someone named Howard. I'm sorry, go ahead.
On that one, you don't think moving a car is a deceitful means to avoid its repossession?
I think it's analogous to retail theft. I mean, what we have is case law that says retail theft doesn't involve a false statement or doesn't involve dishonesty. That, to me, that seems a little bit counterintuitive because it's inherently it's hiding something and taking it without paying for it. But that is our case law, and I think moving a vehicle so that it's not repossessed is more analogous to a retail theft than it is to a false statement, something like a perjury or a bad check or a forgery where there's an inherent misrepresentation. Allegedly, Mr. Poirier made threats against someone named Howard. I don't think that's probative of truth.
Threats against who, I'm sorry?
I'm not, a person named Howard.
Okay.
There are police reports from American Fork Police Department regarding a scheme in which Mr. Poirier was selling Rolex watches that were later found to be fakes. That, I believe, would be slightly probative of truthfulness because of it's probably a theft by deception if it were substantiated. I think, though, that it's outweighed by the, excuse me, the low probative value under 403 comes from the court's holding in State versus Valdez that when we're talking about prior bad acts that did not result in conviction, the question of whether they even happened becomes, well, it reduces the probative value and it leads to the potential for questioning that would confuse the issues.
4B determination.
I'm sorry, what was that?
Whether or not the defendant or whether or not the witness committed the act is a 104B determination. Could a jury reasonably find that the prior bad act was committed?
I don't know, Your Honor. This case was referred to the county attorney for prosecution. It was returned to American Fork Police Department for lack of evidence. That's coming up on a year in December that happened. We have not received any subsequent reports. And, you know, this is anecdotal, but my experience is that means there aren't any more coming and that the lack of evidence cannot be remedied, which to me would be a matter that would confuse issues, whether this even happened or not. There's a domestic violence incident alleged to have occurred in July of 2012. There's no conviction on that, and it's not something that speaks to truthfulness or untruthfulness.
Is it a felony?
No.
Okay.
There's trying to pay rent with guns. I think Mr. Poirier is overheard on a telephone call encouraging, or no, I'm sorry, this is a different incident where he tried to, he was short on cash, tried to trade guns for rent. The landlord thought that they might be stolen and called police. Whether they were stolen has not been borne out, and I don't think it goes to his truthfulness. Lastly, there's a sexual battery case from 2007 that resulted in a Class A misdemeanor conviction. This is an incident when Mr. Poirier was 19 years old. He was involved with a girl who was, I think, 14 years old. He represents that she lied about her age, ultimately took the conviction as a Class A misdemeanor as a compromise, I think, based on the threat of a much worse conviction. This, I don't think, is probative at all of his truthfulness, and it's highly inflammatory.
Any evidence that the sexual offense was accomplished by deceit or fraud?
The only knowledge I have about it, Your Honor, is that the deceit was on the victim's part, that she told him she was older than she was.
Okay. Anything else?
Finally, there's a statement, I believe, to his wife about the lies that he tells her. He apologizes for it. I think the proper mode of impeachment based on that statement would be to call his wife to testify about his reputation for truthfulness rather than to offer extrinsic evidence, which is clearly excluded by 608B.
Is there any issue of privilege here, or
maybe,
or does a person calling from the jail understand that the phone call's monitored and so there's no privilege?
You know, Your Honor, if it were a defendant, I think we would certainly argue the latter. They waive their privileges when they call from the jail.
Yeah.
So in this instance, it would be incongruent for me to say otherwise, I think.
Okay. All right. From the defense?
Your Honor, we believe that Your Honor has largely ruled on this in relation to the motion that was filed, which Your Honor denied excluding Mr. Poirier, but indicated that she would allow liberal cross-examination of Mr. Poirier. And I believe that most of these issues that the state has addressed are tied to Mr. Poirier's truthfulness. In not only his truthfulness, but also evidence of bias, prejudice, or any other motive to misrepresent, which is specifically allowed to be inquired into pursuant to Rule 608C. Mr. Poirier was incarcerated at the time that he made most of these statements that we're addressing, and had a substantial motive to try and avoid responsibility for his actions.
Can you just tie those up for me? Let's begin with guns and knives in violation of probation. I agree with you. The fact that a probation violation was pending and unresolved would give rise to a motive to misrepresent, but does it matter for what?
I think that it does. In relation to the guns and knives, his probation officer had told him repeatedly that he was not to have weapons while he was on probation, and he continued to refuse to comply with those obligations and even lie to his probation officer. There is one of his phone conversations where he goes on his own little speech to his wife about how the government isn't going to tell him what he can and can't do with his guns, and that he's going to get off probation and keep his guns regardless of what the government says. Something to that effect. I'd have to go back and read it to get the exact words, but something along those lines. He also talks about the seriousness of the guns violation in relation to what he is being held in custody for, which shows increased motive to take actions such as we believe, misrepresenting in relation to Mr. MacNeill in order to avoid the consequences for what he perceives to be a very serious probation violation. In relation to his use of steroids, again, this is another matter that goes largely to his motive, because he's admitted on the phone to not only using steroids but directing his wife to sell steroids, even having inmates that were previously incarcerated with him hook up with his wife after they are released from custody and purchasing steroids. It's an illegal act. He has a great motive to try and avoid responsibility for that, which we think supports them.
So on that one, he's not been convicted, but is there any evidence that at the time he agreed to testify for the state that he was aware that authorities knew about that act? That to me that's important.
Yes. There are, in relation to the drug offenses, they are scattered through his phone calls. So his phone calls go from December through the middle of February. And the interview with Mr. Poirier in the state occurred on January 31st. And so I believe that the inmates know that the phone calls are being recorded, and so he either knew or must have known that there was evidence that the authorities had in relation to what he directed his wife to do on the phone. And frankly, he had a pretty cavalier attitude about what he said on the phone, I think, because he felt he had this ace in the hole, that he wasn't going to be prosecuted for his wrongdoings because, as he said a number of times in his phone conversations, the state needs him. And so he had an attitude that he could get away with pretty much anything on the phone. And in fact, there hasn't even been a police report that I'm aware of prepared in relation to his actions on the phone. In the state's pleadings, they indicate that they haven't seen one, and if they were to receive one, they would review it. But obviously nobody has prepared one, even though there's good evidence of.
So your thinking is that it doesn't matter whether he knew at the time he agreed to cooperate with police, it doesn't matter whether he knew that authorities knew about the steroid use and sale. Could have happened afterwards. It goes to this issue of him feeling like he's free of the state's reach because they need him.
Yeah, they're not going to prosecute him.
Okay.
And he says that on the phone.
Next is the prescriptions from Dr. Moore.
Yes, the prescriptions from Dr. Moore, he specifically directs his wife to lie to Dr. Moore and to tell Dr. Moore that he's out of town in relation to his invention when he's really in jail. And then they discuss selling the prescriptions and that his wife doesn't need to work because she's got Dr. Moore, and that they can make about $1,200 a month with that. And so there is deceitfulness in relation to the acquiring and selling prescriptions from Dr. Moore. In relation to the toddler carrying the drugs around, I didn't intend to inquire about that.
Not paying the landlord.
And the landlord, again, that's another scheme to defraud. It's not just simply not paying the landlord, it's Mr. Poirier directing his wife to lie to the landlord and to tell the landlord that they're going to buy the house and to ask him to give him a couple months in order to buy the house, and that Mr. Poirier's got a lot of money. When he gets out of jail, they'll be able to take care of this. And then he tells his wife that once he's out, of course, they won't buy the house, and it'll take a long time for them to get evicted. And so this.
And he says that, tell him to tell them we're going to buy the house. We have no intent to do it. It'll just buy us time.
Right.
Okay. Okay.
In relation to getting financial help from the LDS bishop, it's yet another scheme. His wife says that she's going to go to a church which appears to be a non-LDS church and ask for financial assistance. Mr. Poirier says, nope, they won't give you any assistance. You need to go to the Mormon church where they'll help you out. He specifically tells her to inquire of somebody that appears to be an older bishop, Bishop Niels, and tells her not to tell the bishop about Jason's circumstances. So I think, again, that's another misrepresentation, part of a scheme to get benefit from others.
Okay.
Phone call about repossession of the car.
Yeah, moving a car to avoid repossession.
It's yet another scheme of Mr. Poirier's to avoid consequences of his actions. Rather than accept the consequences of his actions, which we believe is what he's doing in relation to Mr. MacNeill, trying to avoid consequences of his actions, he's making up a story to be able to get favoritism from the state. But the same thing that he does with the car. He tells his wife to go move the car in order to avoid the appropriate repossession of it because they haven't paid the bills.
Okay. Threats against Howard. I don't know what that's all about.
Yeah, there's discussion in the phone calls about threatening Howard. I don't think I intend to go into
Okay.
threats of violence. Oh, great. Yeah, I was just reminded that Howard is the landlord, but my intent with Howard was more towards the dishonest scheme to defraud him rather than threaten him.
The American Fork Rolex watch scheme.
Your Honor, that one mystifies me a little bit as to why there haven't been follow-up police reports, because the police officers actually went to substantial lengths to prove that the Rolex watches were fakes. They collected them, took them to a jeweler, and got certifications, signed statements from the jewelers that they were fake. They had multiple reports of Mr. Poirier defrauding people, representing Rolex watches to be legitimate when they were fake, and so for some unknown reason they haven't submitted the follow-up information that was requested by the state. I don't know why the police haven't followed up, but there is ample evidence to show that was yet another scheme of Mr. Poirier too.
When is that alleged to have happened?
That is alleged to have happened in the year mostly of 2012. Well, I guess entirely of 2012 and even before.
And when are the police reports dated?
There's a few police reports throughout 2012. The one that ultimately was submitted was in December of 2012.
Does Mr. Poirier know that he's under investigation? Was he ever spoken to? And his knowledge, again, it seems to be important.
Yes, I believe he does know, because at the time that they arrested him, they searched all of his house and seized all of his Rolex stuff.
And that was in 2012, before he was incarcerated at the Utah County Jail?
Exactly. That was part of the whole search that led to his incarceration.
Okay. The domestic violence conviction.
He actually ultimately wasn't convicted. The charge was dropped, I believe, because his wife recanted her story. I didn't intend to go into that because the evidence that we have is her recantation, and I don't have specific evidence of him asking her to recant. And then the next
I've got trying to pay rent with guns.
And then that goes back to the landlord issue, and I didn't intend to really go into trying to pay rent with guns. My focus with the landlord was this scheme to defraud the landlord.
Okay.
The sexual battery issue does involve a substantial amount of Mr. Poirier. There was a protective order that was put in place, and Mr. Poirier lied on numerous occasions in relation to the protective order to have access to the minor.
Help me understand that. What did he do?
He text messaged her, had other people use third parties to contact her. The police contacted him, and he lied about having contact with her, and then ultimately confessed. He had ultimately 8 or 9 charges of violation of protective order, something along those lines. Maybe it's 5 or 6. I don't remember the exact number, but it was multiple charges of violation of protective order.
How long ago was that?
That was in 2008 and 2009, I believe. That sounds right?
I'll double check. I thought it was 2007.
It was back in that.
I mean, it's not an act of dishonesty to violate a protective order, right? It's the
The line about the act. It's honest.
okay. And for the record, I think I'm clear about this. He was already convicted, sentenced. It's all done by the time he's giving statements to the. Is he?
I don't think so. I think that he'd only had a civil protective order at that time, and then it was the line about the contact that led to the subsequent.
That was a bad question. My question was, he has been sentenced, the case is finished and closed at the time he begins to give statements to the police in this case.
Oh, yes.
It's finished. There's not an issue of it being over his head in some way.
That's correct.
Okay.
It was, I'm sorry, it was 2008.
2008. Okay. The apology for lies that he's told his wife. Do we know what lies they were?
Yeah, he lies to her multiple times throughout the recordings.
What are they? What are they lies about?
You know, frankly, I didn't intend to get into that. I was just going to address the specific schemes really, rather than get into a general statement of an apology for lies.
Okay. All right. Okay. Thank you. Anything more from the defense?
I think, as I alluded to at the beginning, that we believe that all these statements are admissible under 608C as well as under a 404B is other act evidence that's probative of Mr. Poirier's motive to misrepresent in this case.
Okay. Anything else from the state?
Your Honor, I stand on the general proposition. I think that 608, I think, is clearly designed to not allow parties to impeach a witness by trotting out every misdeed they may have in their past. And it would only allow specific instances of conduct that speak directly to the character for truthfulness. When it comes to Rule 404, I think a lot of this, as Mr. Spencer admitted, is being used to show, look, he made it a scheme to avoid consequences here, therefore he's more likely to be using a scheme to avoid consequences here, and I think that's clearly improper propensity evidence. To the extent that...
How do you respond to the argument that some of these things, like the pending probation violation, it really goes to this issue of motive? I have a reason to tell the state what the state wants to hear in this case to get out of punishment.
Sure.
That seems to me to be prototypical bias that 608C would
I agree.
contemplate.
And when it comes to, for example, in spite of the Supreme Court's ruling on retail theft not being a crimen falsi or whatever, the state is not going to object to the use of the retail thefts that he was in custody on, even though they ended up ultimately being resolved as misdemeanors, because I think they do speak to that motive, and as well as the probation violation.
Okay.
The specific nature of the violation, that he's got multiple guns and knives, and he doesn't think the government should be interfering, and he's got a distorted concept of what the Second Amendment means.
But
I don't think
there's a difference, though, between drinking a beer and having a weapon when you're on felony probation.
Sure.
I think that's the point, is maybe how serious it is really increases the motive to misrepresent.
I understand. First of all, he's never been convicted of a felony. He was not on felony probation at the time. Mm-hmm. Secondly, I think the gravity of the potential consequence, the recommendation for the sanction is actually more probative of his motive than what the underlying violation might be.
What was it? The recommendation.
I think it was 365.
Yeah, so he's got a year.
Yeah, so he was being sentenced, he was being recommended for statute based on the violation. It also, having that be the evidence about his motive, avoids the potential for confusion of the issues on getting into what exactly were the violations that were alleged, how many of them were proven, did he admit some, did he deny some, what is the level of proof that we have for how many guns he had.
Did he admit to the weapon violation?
I don't know that. Do we know? I'd have to follow up on that, Your Honor.
Do you know?
I don't believe that it actually came up in that fashion because they had a number of, I don't know is the answer.
Don't know.
They had a number of violations and he expired a sentence when he was picked up.
When do we expect to hear from Mr. Poirier?
We have 3 witnesses ahead of him who are expected to be relatively brief. We might get to him before lunch, but probably after.
Okay, I think we need to. I've got to think about this, and I'd like to know the answer to that question, is did he admit?
Okay.
Okay, so your position is it really doesn't matter what the violation was. What motivates him is the 365-day sentence that's recommended.
Right, and that was something that I was prepared to ask him about in the event that what deal he got in exchange for his testimony came up. Generally, Your Honor, I think most of these have a low probative value, if they have any at all. I'll concede that defense counsel pointed out some of the some deceit in these instances. I do think that value is low, however, when compared to the potential for getting bogged down into how much of this actually happened, what are Mr. Poirier's explanations. All of that distracts us, takes us off the path of whether defendant killed his wife and whether he obstructed justice, and it takes us down into a morass of what Mr. Poirier may have done in his past. And that outweighs whatever probative value for his honesty that those incidents might bear.
What would your cross-examination look like on the sexual battery lies? Would you have text messages or something? What would you be?
Yes.
Help me understand what that's going to look like.
Is this related to text messages and using a third person to try and get around protective order?
The protective order? Is that dishonest? I mean, it's illegal, but is it dishonest? To say, you go contact her for me, it's almost it's nothing dishonest about that.
I believe that it's inherently dishonest where he knows that he's got a protective order in place and he creates a scheme for someone to on his behalf go violate the protective order in order to avoid detection, at least attempt to avoid detection. I think that is all inherently dishonest.
Okay.
May I respond briefly to that?
Yeah.
I think that's a very expansive understanding of dishonesty. Under that understanding of what dishonesty means, a retail theft should be a crime and falsity. I mean,
Any avoidance of detection after
any
having
avoidance of detection,
committed a crime.
any attempt to not admit to a crime, if when questioned about it, anything that runs afoul of the law could be characterized as something that is dishonest. And I think in the common understanding, it is. But under Rule 608B, it's a very narrow allowance for convictions or acts that speak directly to a false statement. And it's analogous, I think, to what's allowed under 609. The acts that require proof of or require admission of a false statement or an inherently dishonest act. And I would disagree with defense about skirting around a protective order. I think that's what's that? Or speeding. I mean, again, any crime could be seen to be dishonest, but I don't think that's how it's read by 609 and 608.
Okay, thank you. Anything else? Yeah.
We'll elaborate on the facts just a little bit more. One of the instances, in addition to the saying somebody else was doing the text when it was really him, he had a friend call the minor and ask the minor to meet the friend at a residence because he had a gift. Because the friend supposedly had a gift for the minor, but then when the minor got there, then Mr. Poirier was there, or waiting. Mr. Poirier was set up as the gift. I think that's inherently dishonest.
Did the child? How was the protective order obtained? Was it the adults on behalf of the child? Was the child in favor of the termination of the relationship, or was this against her will, if you know?
I believe that it evolved over time. Initially, the child was in favor of the relationship.
Continuing. Yeah.
And then it got to the point where the child was no longer in favor of it.
And at the time that this event happened, was the child deceived, or was the child complicit in meeting the defendant?
My recollection is the child was upset at that time.
Okay.
But,
I feel like I need to know more about that. If the child's complicit in going to meet the boyfriend, that's not an act of dishonesty. Everyone was in on the arrangement. But if she's deceived, didn't want to see him, and she's deceived, that's a little different.
and I'll have to re-review the police report.
Will you check that for me?
My recollection was that the child was deceived to
Okay.
arrive at the place.
All right, thank you.
If I may make one more comment on the guns. Mr. Poirier, at the time that he was arrested on probation, he was under indictment for a felony charge. He was a restricted person. He also had a protective order violation charge that he had been convicted of multiple times, and so he is a federally restricted person even today in relation to possessing guns. And so there's no justification for him possessing guns other than his outright refusal to comply with both the directives by his probation officer and...
You said that you had evidence that he had lied to his probation officer. What is that?
The probation officer submitted a statement in the MSGR report for sentencing, and she recommended that he be sentenced by statute consecutive to the 6 months that he was serving on the probation violation. So she recommended that he serve an additional year after the 6 months. And the probation officer comments in this report, this agency believes that due to Mr. Poirier's constant untruthfulness with this agency, his blatant disregard of not having weapons in the home and the amount of weapons and ammunition located in the home, he is a huge risk to the community.
So his disregard for that requirement, but did he lie about it? He says constant untruthfulness. Does she say anything more about that? What he lied about?
allegation in the reports that we have that he used his wife to go and purchase guns for him to sell, that he obviously couldn't purchase himself. But the probation officer doesn't address those specifics in her report.
Okay. All right, thank you.
I want to belabor the point, but can I respond to just a couple of things?
It's your motion. You have the last say. Go ahead.
I appreciate that. On the issue of the sexual battery case and the 14-year-old, I think I understand the court's purpose in inquiring into the details in order to make a proper ruling. I think this inquiry, though, exemplifies the high potential for confusion of the issues with the jury. Obviously, Mr. Poirier has a different version of events that he'll want to explain when he is impeached with this event that happened 4 or 5 years ago now. You know, whether the girl was willing or not, you know, we're obviously not going to call her in to tell that to the jury. Defense counsel will impeach Mr. Poirier by saying, you know, you deceived her into coming and she didn't want to come, and he's going to say, no, she did want to come. And I think that's exactly the confusion that the rule is trying to prevent. Same thing with the probation officer. When it comes to her opinion about his truthfulness, that's clearly a 608A thing. Testimony. And my understanding is that Mr. Spencer intends to call her to testify about his reputation for truthfulness. So the details of which violation was honest, or which violation was proven and which one wasn't, and whether he lied about some but not others, I think, again, that bears out the grave potential for confusion of the issues.
Very good. Thank you. I don't want Mr. Spencer to feel double-teamed. Is this on the same motion?
Well, I was looking at the record on the order to show cause, just to make a record. You'd asked a question on the facts.
All right.
You
Go
want to
ahead.
take it to it?
Just tell me. I just
Okay,
don't want
so-
you to make argument.
The order to show cause on the protective order violation had 2 allegations. One was owning, possessing, or having under his control an explosive firearm or dangerous weapon. Allegation 2 was being uncooperative, uncompliant, or untruthful in dealings with APMP.
What?
And then the minute entry does not show if he made specific admissions. It simply says his probation is revoked, as does, the minute entry says that, as does the post-sentencing order of the court. So it doesn't say whether he admitted to those or whether there's an evidentiary hearing or anything like that.
Okay. I appreciate that. Thank you. All right. I will take this under advisement. We'll call Mr. Poirier after the lunch break, which I hope to have maybe at 1 at this point. Or maybe we just keep going through at this point. The jury may want to just go through to 3 o'clock and have 4 hours. It's really a half day today is what it's shaping up to be. And I'll just have to take a few minutes to rule on this before Mr. Poirier is called at a break. Let's have the jury in.
Lastly, Your Honor, the court ordered the state to provide pictures of it.
Yes.
Before, may I approach?
You may.
Provided a copy to Mr. Spencer.
Very good.
I wondered, with respect to how to logistically do this, I wondered if when we have the witness come in and take the stand, for record purposes, perhaps counsel approaches the bench and with the white noise, we make a record of who the individual is and their number.
Okay.
As far as
I think that's a good idea. Thank you.